In our leading story this morning, all eyes are on the North Gauteng High Court in Pretoria today as Judge Bashir Vali is all set to explain his controversial ruling on Zuma's cabinet reshuffle.
Last week, Judge Bashir Vali had ruled on the DA's urgent appeal that President Zuma must hand over all records explaining his reason for the firing of Pravin Gordhan and Mcebisi Jonas. He had said that he'll provide reasons for the ruling on May the 9th, which is today. The ANC has asked the executive to appeal the ruling, saying that it was a clear case of judicial interference in matters of the executive. The party also accused the judge of pandering to the opposition, who was trying to co-govern via courts.
Are they saying that the president does not have constitutional authority to make such announcement? If that's what they're saying, then they are making a mockery and exhibiting a high level of ignorance. Okay, that's why you have what you call a bias ruling, a bias judgment, which can, be challenged. So he has exercised an executive decision which has given him the powers to do that. If you go to chapter 5 of the Constitution, and if you look at 92.1, he has the mandate to do that. So I don't understand on the foot they are standing.
It is actually a slap on the face of the South African people who are relying on this constitution to can be governed and treated properly. The story that the DA is going to use a so-called intelligence reports, it is not going to fly. The president never cited that report.
The Society for the Protection of the Constitution says that the ruling is so wrong that the only reasonable interference is that it is prompted by an ulterior motive. While they further argue that Judge Vali wrongly relied on Rule 53.1 subsection B of the Uniform Rules of the High Court to make the order he did. They say that the rule in question obliges an administrator to provide reasons as per law, but whether the rule applies to Zuma's removal of Gordhan can only be adjudicated by the court hearing the main application. Lastly, they state that the judge preempted a finding of urgency that a court hearing the main application will be required to do.
Surely the DA does not have the power to correct the record of proceedings where they were not even part of their proceedings. So this Rule 53, which he relied on, is not in line with the facts as they have occurred and what the Constitution says as to who is the decision maker about cabinet ministers that are to be appointed and removed.
Well, the Decolonization Foundation leader Mzwanele Manyi joins us right now in studio. Very good morning to you, sir. Thank you so much for joining us. Can you just take us through the reasons why the Decolonization Foundation is actually taking up this matter with the SAPS?
Yeah, look, I think we are still very shocked, actually, that we are where we are as a country, where you find a judge that is blatantly playing into the political realm. The first thing that should have done, in our view as the foundation, is that the judge should have listened to what the DA is saying and then asked the DA if what have they done to get remedy to what they are seeking. Did you go to Parliament? Did you use the Parliament? Did you exhaust? Did the President refuse to go to Parliament? Stuff like that. And should have even interrogated the rationality of the question that you are asking about two. Do you have a rational response to the rest of the 8? All of this, it just shows just how wrong this thing is on all angles, at all levels. We shouldn't be where we are. So we argue that this judge is actually corrupt. This is abuse of public resource. This is abuse of our courts. This is getting our courts to play into the political space. The president, when he made this decision, he was informed by the Constitution. Everybody in the country has been saying the president must respect the Constitution. The president has done exactly that. Section 91, subsection 2 of the Constitution gives the president the power to appoint and to dismiss ministers. That section says nothing about give reasons for what to do. So for people to come and read things that are not into the Constitution because they've got ulterior motive and all kinds of political shenanigans in this, what's worse, a judge that is supposed to know better, the only people who are supposed to help us resolve our disputes. In fact, they've put petrol into the fire by participating in this thing. Why would a judge want a president to explain his reasons to an opposition party when the Constitution does not require him to do so? The judge has abused the court the judge has acted in a very corrupt manner. Our monies as taxpayers are being wasted because this judge is abusing his position in court. In fact, we have asked, as a Decolonization Foundation, when we reported the matter at the police station, that the judge must really be investigated because we are really convinced that the judge is corrupt. He must be investigated for what meetings did he have with the DA prior to this thing? What are the telephone records saying between him and the rest of Save South Africa entourage? Because this is all a political game. What are his bank accounts? What is his lifestyle audit? So this judge indeed has put the judiciary into disrepute. In fact, the next step that we'll be doing as the foundation is to take him to the Judicial Services Commission to have him removed from the bench. We can't afford to have judges that impugn the integrity of the judiciary.
Well, what does the Decolonization Foundation expect to find in their probe of Judge Bashir? Because if you look at his collusion or his expected collusion with the DA, I know you've said that you're going to go through the conversations and so on that he had with Safe SA members. So what do you expect to find in this probe?
Look, if you have somebody that has got the energy to make a ruling, and in fact, if he was so clear about this ruling, he would have already stated the reasons. We have to wait a whole week or just under a week for him to even say what the reasons are. As we don't even know where he bases his reasons. But on the face of it, this is an order that is not supported by anything in the Constitution. Therefore, it just means that something else is driving this. So for us, the order itself is prima facie evidence number one of corruption. We shouldn't have this order. The order is number one evidence of corruption. So now, in order to back up this with other evidence, we already have evidence number one is a court order. That order is corrupt. That order is inspired by corruption, in our view. And I was saying now, let's look at more evidence to corroborate the first evidence that we have. So when we get these telephone records, his lifestyle audit, his bank accounts and everything, we'll be able to see that, in fact, where is this all coming from.
Well, thank you so much for joining us here in the Ground Report. We do hope to speak to you after the judgment, or the reasoning behind the judgment is actually delivered later on this morning. That was Zuma Cabinet of the Decolonization Foundation, just giving us some insight there into the reasons behind wanting a probe into the judge's decision and the judge himself.